Director Penalty Notices, understanding your personal liability. Welcome to IO Insolvency Options with Darren Vardy, the Managing Director of Insolvency Options and a registered liquidator with over 30 years of experience helping businesses and individuals navigate financial challenges. In today's episode, Darren demystifies Director Penalty Notices, or DPNs, and reveals how these powerful ATO enforcement tools can make directors personally liable for company tax debts within just 21 days. He explains the difference between standard and lockdown DPNs, the three options available to avoid personal liability, and why keeping your ASIC records up to date is absolutely critical. You'll learn about the history of the DPN regime, what debts are covered, and the crucial steps every director must take to protect themselves. I'm your co-host Anthony Pearl. Let's dive into unlocking more about insolvency options. Well, Darren, welcome. And I want to ask you a question that I hear this terminology being thrown about a little bit from business owners. I hear this terminology of a DPN. Can you tell me a little bit more about what that actually is and what it means?
Sure. So the terminology DPN is short for Director Penalty Notice. And a Director Penalty Notice is a debt recovery document issued by the Australian Taxation Office for outstanding debt in relation to generally GST and or PAYG, where if left unresolved, a director can be made personally liable if they don't take certain action within 21 days from the actual date of the notice.
Wow, okay, so quite a serious thing to understand. So, I guess the first thing is what is the immediate action that they need to take?
Sure. So within that 21-day period, there are generally three different types of action that can be taken. The first action is pay the debt, which is pretty common sense, one would suspect. The second action is to come to a payment arrangement with the ATO. Now, the ATO do allow companies to enter into payment arrangements to repay debt, and therefore they will allow the directors to enter into a payment arrangement in respect to any director penalty notice amount. However, the ATO usually requires a personal guarantee from the directors for any payment arrangement entered into in regards to director penalty notices. And the other way of avoiding personal liability, or the third option available, is to appoint an administrator, an external administrator. Now, that external administrator could be the appointment of a voluntary administrator. It could be the appointment of a small business restructuring practitioner, or it could be the appointment of a liquidator.
Okay, so just briefly before we get more into that, just tell me what the difference is between those three.
Sure. So with a voluntary administrator, generally that is a precursor to a deed of company arrangement. So it's a mechanism within the Corporations Act that allows companies to avoid liquidation by virtue of the proposal of a deed of company arrangement whereby they can repay their creditors, maybe not necessarily in full, but in part over a period of time. And that is one way to avoid liquidation. Not dissimilar to that is the small business restructure. These are for, as it indicates, small businesses where their liabilities are less than $1 million. However, they must ensure that their superannuation obligations are up to date and all their lodgements are up to date also. As I said, again, that is another way, another mechanism of avoiding liquidation, which is finality.
And I guess all of this happens in a very short period of time, right? Because 21 days is not particularly long. If the debt's a few $100s, not a big deal, but I gather that what we're talking about here quite often is a significant amount.
Yeah, look, quite often we're dealing with amounts that have been accruing over a period of time. There may have been previous payment arrangements, company payment arrangements in the past that have been defaulted upon. And therefore, the ATO has effectively, in its view, provided plenty of opportunity for the company to remedy its issues. And they've issued the director penalty notice against the director as a manner of enforcement to show the seriousness and to try and force the director to act in one way or another to resolve the issue. And as you say, it is a 21-day period from the date of the notice with which the director needs to act. So therefore, any director should really seek advice swiftly to understand the financial position of the company and the options available, albeit repayment, payment plan, or appointment of an external administrator.
And I guess one of the things to be aware of in this situation is that many businesses don't necessarily have too many directors. They might actually only have a sole director. So it might be the business owner themselves who are in the middle of all of this.
This is correct. Yes. Yes. But sometimes, there may be traditionally a lot of the older companies may still have two directors, husband and wife and the like. So when you look at a director penalty notice can be issued against either director. The director penalty notice is a joint and several liability. So when we look at the liability of the directors, the taxation office will look at recovering from either director the amount which is noted in the director penalty notice.
And I wonder if people think about that possibility when they're going into, creating this company structure in the first place, whether there's the advantages and disadvantages of having a husband-wife combination, for example, as being the directors.
I think in recent years, almost probably decades, with the changes in the Corporations Act to allow sole director companies, we are often finding that the traditional two-director husband and wife type companies have not been used as much in recent times. So yes, we have seen a change in, who is the director of the company, as well as how many directors are required.
Yeah, I suppose does that put the legal onus in a different place then, if that the possibility of separating those two enables certain things to be attached to one partner and certain things to be attached to the other, I gather.
Yes, correct. And particularly where, the spouse or a spouse may not necessarily have any day-to-day involvement with the company. However, the obligations and the duties of a director, if appointed as a director, can be quite onerous, and the spouse who is not actively engaged in the actual company can still be held liable for various obligations, such as tax debt and potentially insolvent tracking.
So tell me a little bit more about the history of the director penalty notices. I mean, have they been around a long time? Are these things that people should know about?
So, believe it or not, the director penalty regime has been around since 1993. I actually had been in the industry for 4 years at that point in time. So I saw the whole roll-in of what was called the voluntary administration regime that was introduced, which has been updated throughout time. But prior to that point of the introduction of the voluntary administration regime, the tax office held a priority over repayment over all other creditors, employees and ordinary unsecured creditors. So as part of the research at the time, the government was looking at what type of regime can we put in place to enable these companies to restructure and not simply just fall into liquidation. Having conducted their research, they then determined that they would need the Australian Taxation Office to be on side with the restructure. And the only way that they could do that is if the Australian Taxation Office relinquished their priority status and became an ordinary unsecured creditor. However, the tax office was unable to vote on any restructure and have voting rights as an ordinary unsecured creditor. Now, given that the ATO would essentially be giving up this priority position, they required a mechanism to enable the recovery of certain company tax liabilities, such as, well, back in the day it was called group tax, but such as PAYG withholding tax obligations and the like. Now, with that, the director penalty regime was spawned to enable it to have a far greater ability to pursue debt owing and really focus the directors on the task at hand, which was stop the ever accruing debt owing to the tax office and to organise a repayment of same.
I mean, if there are other debts and things in place, is this getting a priority and what does it cover?
So the other debts that are in place, the director penalty notice, that is, covers, as I indicated, unpaid PAYG. It now covers GST, unpaid GST, and also covers the payment of superannuation.
So there's a fair onus on everyone to do that. I think superannuation is the interesting one here as well, isn't it? Because that's become much more of an obligation and perhaps wouldn't have expected that that was covered under this.
Yes. So the ATO has the ability to issue a director penalty notice in respect to outstanding superannuation. Outstanding superannuation is still afforded a priority over ordinary unsecured creditors. It has the highest priority alongside wages in respect to the priority of repayment. And quite often, like tax, when a business's cash flow starts to suffer, it's not the superannuation funds that are knocking on the door of the business to make sure payment happens as and when. The trade creditors are generally knocking on the door. Akin to the ATO isn't necessarily knocking on the door in respect to PAYG and GST. However, with the reporting regime, they can enable the reporting to ensure that the debt is determined and that the tax office is aware through the simple touch payroll system as to the debt that's actually outstanding in respect to superannuation and PAYG. So when it comes to superannuation, that falls under what's called the lockdown director penalty notice regime. So what that means is that the director can be made automatically liable upon receiving a DPN in respect to superannuation from the tax office.
So you talk about the lockdown penalty notice. So what else can that cover?
So a lockdown penalty notice can also cover GST and PAYG outstanding. Unlike normal director penalty notices, there is no 21-day grace period to avoid personal liability. The appointment of an external administrator does not remove the director's obligation. The only way to resolve a lockdown DPN is to pay the amount outstanding in full. Now, a lockdown DPN in respect to PAYG and GST occurs when a company has not lodged its BAS returns or IAS returns within 3 months of the due date of when those returns were to be lodged. So by way of an example, if a BAS or an IAS was due on the 21st of the month following the first quarter of the year, i.e. September quarter was due on the 21st of October, if that BAS or IAS had not been lodged by the 21st of January, then any debt owing in respect to that BAS or that IAS would be capable of the ATO issuing a lockdown DPN to the director for the debt owing pursuant to those IAS or BAS.
So I guess the key question is, how do you avoid putting yourself in a situation where you've got these notices coming your way?
So the easiest way to avoid a DPN is to lodge IAS, lodge your BAS, even if you haven't got the cash flow to pay at the due date. That is certainly the easiest way to avoid any director penalty notice in respect to same. Then when it comes to the payment, either make the payment as soon as practicable, or if you are a company is having cash flow difficulties, that's when it's recommended to look at a formal repayment plan with the ATO to repay that debt over a period of time.
The key question as well is, how do they know about these DPNs? Where are they issued? How are they received in the first place?
So director penalty notices are generally issued to the director's address. The director's address is found on ASIC records. So if a director has moved and relocated, the onus is on the director to ensure that the ASIC records are up to date and accurate. If that doesn't happen, what you can find is that the address for which the notice is sent to may not be forwarded on, and it may be that, and there has been circumstances where a director has been pursued by the ATO as a result of being issued a DPN for which the director never actually receives because the director did not update their address on ASIC's records.
And I guess email is not a thing, right, for these, for at this level. They're pursuing it in direct old-fashioned mail.
Correct, they are. This is true. So, when we talk about 21 days from the date of the notice, quite often a director will receive it with only, anywhere between 15 and 18 days until its expiry by the time the mail actually is received.
So I guess the question is now for people, are there words of wisdom in terms of avoiding this if they're becoming a director, or if they're already a director? What are the things they need to be on the lookout for?
So if a person is a director, the words of wisdom for directors is to firstly make sure you're aware of the lodgement dates and when these documents are to be lodged. Make sure that you follow up and ensure that they are lodged by either the company or the company's external accountant. If you are looking to become a director, it's important to note that becoming a director, you have a 30-day grace period effectively. So within that 30 days, you need to do due diligence to determine and make sure that all lodgements are up to date, because becoming a director, you can be liable for any non-lodgements from the past. Now, if you were to find out that there are non-lodgements from the past, then the only way for you to avoid any personal liability from those non-lodgements is to appoint an external administrator. You can't simply resign your position as a director, because when you resign as a director, you are still liable for all the reporting obligations and payment obligations that exist during the period with which you were a director. Now, if you are unable to effect the lodgement yourself, and if you are to resign, you may, as a bit of an insurance policy, you may seek an indemnity from the company or your fellow directors and or shareholders. However, that is only as good as the paper it's written on. So if the company is unable to pay, the company is unable to pay. If the directors or the shareholders do not have the financial means to cover any indemnity, it means that you as that resigning director may still be on the hook for whatever the claim is by the tax office under those lockdown DPNs.
Just to round things out on this discussion, I just wanted to ask you as well, we talked earlier about the fact that, quite often we're talking about a business where there might be just one director, or it might be a husband-wife sort of combination. But what about when we're talking about slightly larger companies where there are multiple directors? Is the same level of responsibility still there regardless if you're a director of one area of the business versus another?
Yes, there is. So unlike a large multinational, which may have non-executive directors, the majority of businesses are Pty Ltd, so they're proprietary private companies. And so if you are a director, you have all the duties and obligations set out in the Corporations Act, irrespective of what your role is within the business operationally. So it's really important for individuals to understand the risks associated with becoming a director, because inadvertently you could be found that you are liable for debts owing to the tax office for which may have been incurred prior to you becoming a director. So on that note, if anyone is actually asked to become a director, it may well be worthwhile before signing on as a director to do some due diligence around the taxation reporting and payment obligations of the company to ensure that it is up to date at the time of providing a consent to act as a director and being placed on as a director of a company.
And that's all we have time for in this episode. Next time on IO Insolvency Options, we'll continue exploring director penalty notices with real-world case studies that reveal the devastating consequences of outdated ASIC records and the critical role of registered agents. Darren will share shocking examples of directors who nearly lost everything due to simple administrative oversights. It's essential listening for every company director. For details on how to get in touch with Darren and his team on insolvency challenges, please consult the show notes. This podcast is produced by my team at podcastdoneforyou.com.au, helping professionals share their expertise through powerful podcast content. If you found value in today's episode, please like, comment, and subscribe to IO Insolvency Options. Until next time, remember, there's always a way forward when you know your options.